Good afternoon, Ms. Hofmeyer. Good afternoon, everybody.
Afternoon, Chair.
Yes. Are we ready?
We are indeed. Chair,
Yes.
There are two legal representatives who'd like to place themselves on record if they may. The second of them want to raise some matters for your consideration. I propose that he be afforded an opportunity to do so, and then if necessary, there will be a response from the legal team. And thereafter, my learned friend, Ms. Buthelezi, will be presenting the evidence of Ms. Patudi. Thank you.
Yes, thank you.
Chair,
Yes.
my name is Julian Knight. I'm appearing on behalf of witness Tlatsana, who's been summoned to appear.
Thank you very much.
Good afternoon, morning, Chair.
Good afternoon.
I'm Ngabetu Buthelezi, appearing on behalf of Mr. Brian van Wyk.
You'll just have to raise your voice.
Mr. Brian van Wyk.
Yes, thank you.
Sorry.
I understand you'd like to raise some issues.
Indeed so, Chair.
Yes.
Firstly, Chair, we want to bring an application for condonation on several points. One, for non-compliance with the rules of the Commission, in that it is our submission that we were not served with any of the notices. Now, Mr. van Wyk is already implicated by Mr. Ngwenya. And I understand now, yesterday it was by Mr. Piri, and we anticipate that he'll be implicated by witness Patudi and witness Tlatan. Now, we canvassed the point with the evidence leaders about the service of the notice, and we say that Mr. van Wyk was not served with these notices. The query now becomes this point. The email address to which they were served is an email address received from one of the witnesses in what they said was the correspondence between them. And we dispute the veracity of that email address to say, is it Mr. van Wyk's email address? It's a Gmail account. And that is the only source of that email address. Now, what the challenge then becomes, Chair, is that if indeed somebody implicated to the extent that Mr. van Wyk is implicated by up to 4 witnesses, I would have thought or would have anticipated that the onus to ensure that he receives the notices would go beyond just sending to an email address that you yourselves have never verified, number one. And nothing stopped the Commission from even picking up a telephone to say, dear Mr. van Wyk, can you give us your email address? There's documents we'd like to serve on you. That step was never taken, Chair. And all we have is just the evidence as produced by Ms. Tlatsana. Now, it's not relevant at this point, but it will be in the future, because this company, Koroneka, that is now the substance of the disputes with SA Express, is in litigation in the Northwest High Court under case number M40/216, where the persons that Ms. Tlatsana, or have been stated by Mr. Ngwenya to have been implicated by Tlatsana, have taken legal action with regards to this issue. And I'm not too sure if the Commission is aware, but it is our knowledge that Ms. Tlatsana herself is out on 500,000 Rand bail on fraud charges relating to very similar issues. Now, we want to say, Chair, we come before this Commission to state that Mr. van Wyk has not received notice. And we feel extreme prejudice to the extent that we will now go on to the 3rd witness without us having considered any of the statements as produced. And to the 4th witness, which I understand would be Ms. Tlatsana, who has video or voice recordings or something along those lines where we don't know what they say. So we seek, one, Chair, to be allowed to consider the statements of Mr. Ngwenya the statement of Mr. Phiri, even though that they now have given their evidence. Number two, if the chair can rule in our regard to say the evidence of Patudi and Tlatsana to stand down for us to then submit to the commission our responses to their statements as alleged to have been submitted to us. And we understand and appreciate that this now could have the effect of derailing the scheduling and everything else around the commission. But Chair, if we take it to the extent that we've got somebody implicated in the way that Mr. Van Wyk is implicated, I think it's in the interest of justice, Chair, as a starting point, and in the best interest of this commission, Chair, to at least to be placed in a position where the commission can consider Mr. Van Wyk's statement before proceeding with these witnesses, as is the rules of the commission, Chair.
I will hear what the evidence leader has to say, but let me ask you certain questions so that we can see what progress we make.
Indeed, Sir.
I said last week, I say quite often in this commission, we want to ensure fairness to everybody. And therefore we want to strike a balance between the interests of persons who are implicated, the interests of witnesses, the interest of the public, the interests of the commission, which must finish its work within a certain set time, which is not very long. Now, in terms of bringing an application, if you wish to, if Mr. Van Wyk wishes to apply for leave to cross-examine any of the witnesses, including those who have already finished giving evidence, there is an opportunity to do so. If he was given notice in terms of Rule 3.3, but is outside the 14-time period, he can apply for condonation and give reasons. If there was a delay in him actually becoming aware, he can put all of that in.
Yes.
And if leave to cross-examine any particular witness is granted, he would have that opportunity if he wishes to, and then he would have the opportunity to give evidence himself or to call another witness. All of that just needs to apply. You need to apply for leave to do that. Now, one of the sub-rules in Rule 3 of the Rules of the Commission makes provision that if you as an implicated person feel that you were not given by the Commission or the legal team enough time between the date when you received the Rule 3.3 notice and the date when the witness gives evidence to apply for leave to cross-examine, you may bring an application before the Commission and for such a relief as the chairperson may consider would be appropriate to make sure that you are not seriously prejudiced by that. So there is that provision, and it's meant to take care of situations where people get Rule 3.3 notice late. So that is still possible and can be done. What has happened sometimes is that a witness and a person who is implicated was not notified of a witness who's going to come and implicate him or her. And in those circumstances where the legal team of the commission didn't really send anything, I have been inclined to say the witness we should adjourn the evidence of the witness until later when that person can be notified. Or last week I said that the witness could give evidence but leave out for now evidence that would implicate a particular person, and with a view that after that person had been given a Rule 33 notice, then arrangements could be made for the witness to come back and then give evidence. I just thought I must just give you that framework.
Thank you, Chair.
Because maybe from it you might be able to say to me, Mr. Van Wyk and yourselves want to cooperate with the Commission. You're not seeking to frustrate the proceedings of the Commission in any way, but you would just like a way to be accommodated, and then we might be able to look at a way in which that can be done. So I thought I must just mention this framework before I can hear what the legal team might say. I don't know whether you want to say anything in response to this framework.
Yes, please, Chair. I appreciate those points, Chair. It is not our intention to stall or frustrate the Commission in any way. Our biggest concern is, after having learned, the horse has bolted on the evidence of Ngwenya and the evidence of Piri. The best we can do in those circumstances is to come back with an application to cross-examine on the back of our own version. With regards to Patudi, we don't carry much apprehension towards Patudi. The
Yes.
concern in this particular instance is that of Tlatsana,
Yes.
whom I believe that the evidence of Ngwenya as it stands was a corroboration of her own evidence, but, sorry, Chair, having done it in reverse. Excuse me. Now, we would like to, in particular, there's reference made to things like telephone recordings. And before these get played out in the public domain, as is alleged, the least we could ask is to be granted time to actually verify that, is it really Mr. Van Wyk? Nobody's heard Mr. Van Wyk's voice. And before the Commission takes on record, we need to say, well, let them go ahead and lead that evidence, we'll counter it after. But we need to be placed in a position where we can be with certainty say, that is Mr. Van Wyk, and the authenticity of those recordings can then be verified. So my prayer to you, Chair, in this regard, is to say, if the Commission, we would not object to the Commission continuing with Patudi, but we would ask to be furnished with everything that regards to Tlatsana in the earliest time possible, and then have a return date as soon as even next week or whenever the Commission sits again. So we stand down Tlatsana just for today, for us, because the issue that primarily concerns us is that she's going to be leading evidence on voice recordings. And those voice recordings are most concerning for us, because once the evidence is out on that, whether they are authentic or not, then we cannot reverse that process. And that is the prejudice that I anticipate and am cautioning against. You know, I will not cast aspersions on the integrity of the Commission in any way. However, I will revert back to the point that, difficult as it is, the work of the Commission, I had a discussion with Ms. Hofmeyer earlier with regards to, there isn't a process in these proceedings to come back with the return of service. However, I would think that there would be a standard applicable to the extent that if somebody is implicated up to 4 times or by 4 witnesses, that a mere provision of his email address that you have not verified with that individual would require you to just ascertain that it may not bounce back as an email sent, but if it's sent to some dormant email account that was used or created for that specific purpose that he no longer checks, then we cannot hold it to be true that he received it. And I think it may assist the Commission going forward to say there should be a double check step to say, so-and-so, can you confirm that this is your email address? That's all. And that's even whether it's via text or via a phone call. And we're saying in this instance, before the Commission is saddled with tape recordings, which we find are very suspicious for reasons that I've inferred and insinuated towards, to say there may be other motives at play here. We just want to be granted that opportunity to, one, witness the statements and listen to the tapes, and then allow the Commission to proceed.
I'll hear what Ms. Hofmeyer has to say, and then we can take it from there.
Thank you.
Thank you.
Thank you, Chair.
Yes.
Chair, just to deal first of all with the facts in relation to the efforts that were taken by the Commission to ensure that Rule 33 notices were sent to Mr. Van Wyk. I'd like to go into that in some detail so that you have those facts before you. But in advance of doing that, Chair, I'd like to pick up a point that my learned friend raised at the end. He correctly raised the point that I made to him in our discussion earlier, that it is not a requirement that these Rule 33 notices be served, as that notion accords with process in the course of civil or criminal proceedings. There's an important distinction in our regulations of this Commission between service of summonses, which must take place, that's a requirement of the Commissions Act. The rules, by contrast, in relation to Rule 33 notices, simply talk about notifying. And Chair, in that regard, my learned friend was questioning, well, what level of satisfaction should we then have? And for that purpose, Chair, I'd like to draw your attention to the Constitutional Court's decision in Sebola. The reference is 2012, 5 SA 142, Constitutional Court. Chair, you'll recall that's a decision about Section 129 of the National Credit Act, which requires certain notification to be given to consumers by credit providers before litigation can be engaged in. And a very similar question arose there. Well, what level of satisfaction must the credit provider have when it's dependent on things like a postal service that may or may not be working, etc.? And as I understand, the upshot of the judgment in that case is that there must be a reasonable grounds for regarding it to be probable that it was received. It's not a service requirement, it's not returns of service and sheriffs, it's a reasonableness test. Have enough steps been taken to make it reasonable to regard there as having been adequate notification? So my submission is that that's the test that should frame the question that has been placed before you. And with that in mind, I'd like to give you those facts. Chair, the notices were sent, as my learned friend indicated, to the email address that was used by Mr. Van Wyk in all of his correspondence with Ms. Tlatsana in the course of their engagements. And it was gleaned from the documents that have come into the possession of the Commission. And to that email were sent notices, I'll give you the information, in relation to Mr. Ngwenya on the 30th of May at 4:46 in the afternoon, in relation to Ms. Patudi on the 4th of June, at 12:04 in the afternoon, in relation to Mr. Piri on the 6th of June at 3:18 in the afternoon, and in relation to Ms. Tlatsana on the 14th of June at 3:44 in the afternoon. There were no non-delivery messages received by the Commission pursuant to those emails being sent out. Chair, I'm also informed by the investigators who are with us today in the hearing that numerous attempts over the course of the investigation have been made to contact Mr. Van Wyk, including at the time that we were preparing the Rule 33 notices in order to establish that email address. For privacy reasons, I'm not going to read all of them, but 6 different phone numbers associated with Mr. Van Wyk from the public records that the Commission could access were phoned repeatedly by the investigators of the Commission. Chair, it is in those circumstances that we proceeded with the evidence of Mr. Ngwenya and Mr. Piri. And it is my submission that we should continue with the evidence of Ms. Patudi and Ms. Tlatsana today. So let me deal with that aspect. Why do we continue today, despite an issue having been raised this morning and a contention that there has not been receipt, despite all of those steps being taken? Chair, it's my submission we continue, because as I
should have asked Mr. Buthelezi, but I raised this with you, so you can address it.
Indeed.
And if need be, you can address it later. He didn't, I don't remember that he told me what, as a matter of fact, is the current relationship between Mr. Van Wyk and the email address that was used. Does it remain his, but he doesn't check it? Does it now belong to somebody else? So I didn't ask him to deal with that. So he will deal. I'll ask him when he responds.
Indeed, Chair.
Yes.
And if it's necessary, I'll make submissions thereafter. I would, however, at this point, make the submission that the test is, was it reasonable for the Commission to assume that the notification required under the rules have been given? And it is my submission to you, given those facts, that there was no notification or any step that was not taken that should have been taken, nor an indicator that the Commission should have done more than what it did. And in those circumstances, it will be our submission, whatever Mr. Van Wyk's relationship to the email address is, that we are entitled to proceed with the evidence. And I'd like
It's
to
just that if he has a certain relationship with the email,
yes,
it might make it difficult for him to continue to complain.
Indeed.
If it's
Chair.
another relationship,
Yes.
he might feel that he can still complain.
Indeed,
Yeah,
Chair.
but
And
I understand what you are saying.
Yes.
Yeah.
We
But
leave
that's the reason behind
Of
the
course.
query. Yeah.
Of course, Chair. The high watermark of his argument, however, I submit, whatever that relationship is to have to respond to whether the steps were reasonable or not. And I submit, no matter what that relationship is, the steps taken by the Commission were reasonable. And Chair, if I may, there's a greater significance to these points. And it's a point that, Chair, you made in your debate with my learned friend. This Commission has a limited time in which to complete its work. It cannot possibly be in a position where, despite taking reasonable steps, witnesses can arrive on the day of evidence and say it cannot proceed. There is a balance, as you've said repeatedly, Chair, but against these facts, we submit that balance must stand in favor of the evidence proceeding.
And of course, I think in the case that came up last week involving Mr. Ngasana and Ms. Jiba, I think it was a fact, if I recall correctly, that Ms. Jiba had not been even informed, that there was somebody who was going to give evidence.
Indeed.
And there was, it wasn't the legal team's case that they had taken a number of steps to
Indeed.
try and bring these facts to the fact of a witness coming up to give
Indeed.
evidence implicating her to her attention and so on. So you say this is a case where the legal team and the Commission have done have taken every reasonable step
Indeed.
to try and make sure that Mr. Van Wyk gets the Rule 33 notice. And if, despite those steps, he didn't get it, that doesn't mean that there's been no compliance with the rule.
Indeed.
Yes.
And Chair, then just to deal with the question of prejudice, because that's ultimately what this debate must be about. As I understand my learned friend's submission, the principal prejudice relates to a recording that is going to be played in the course of the evidence this afternoon. Chair, if Mr. Van Wyk disputes that it is him in that recording, that he was there at the time, That version can be put up to this commission in due course in any affidavit that he wishes to present. And on the question of condonation, I should go on record and say as a legal team, we would certainly not oppose any condonation. It is in the interest of this commission that we find out what the true facts are. We want to hear, it is our submission, from implicated persons. Mr. Van Wyk can put on affidavit in due course whether he makes an application to cross-examine Ms. Tlatsana or other witnesses, or whether he simply wishes to place his version before this commission. He can set out the precise grounds on which he disputes it. We can consider it as a legal team, and we can make submissions in due course, and even approach you, Chair, to summons him to give further evidence in due course in these proceedings. So on the question of prejudice, Chair, we submit Mr. Van Wyk's version. That is what fairness is about. It's about giving people an opportunity to be heard. There's no sense in which Mr. Van Wyk will not be heard in the processes of the Commission. If he follows the rules, even with the necessity of condonation, if he puts his version up, it will be interrogated, as all versions are interrogated.
Yes.
Thank you, Chair. Those are our
Thank you.
submissions.
Mr. Buthelez, you do want to start with the question that I didn't ask you earlier?
Indeed so, Chair. Mr. Van Wyk's version with regards to that email address is that it's an abandoned email address, that he is no longer using
So
regularly.
does that mean it remains his email address, but he doesn't use it anymore?
That's what I've been led to understand, Chair.
Yes.
And there's
But
been
he-
years that
He
email
hasn't,
address-
so it's still operational, but,
I'd say it's dormant, Chair. It's a dormant email address.
well, does it receive emails? Well, from what I'm hearing, it looks like it may have received the emails, but the emails may or may not have come to his attention because, from what you say, he has abandoned it.
But by way of illustration, Chair, is how some of these things work, just not even analogy, but practically. You sometimes will set up, let's say, even a Gmail account, forget the password, and never go around to rectifying or remembering the password. And if it was created for a specific purpose at a specific time, you then abandon it. Where I bring it back to, Chair, is here, is that my learned friend here states that they took reasonable steps. And we say there was no reasonable steps. Let's start this point. Mr. Ngwenya, who is a former employer of Mr. Van Wyk, has far more personal information, or the domicilium of Mr. Ngwenya, or of Mr. Van Wyk, sorry, and other details where he's easily contactable. Now,
You are talking about a witness, another witness.
no, I'm saying they were collaborating with the evidence leaders. They could have easily cross-referenced the correctness of the information as to say, if this person is a former employee, what details?
But
do
they
you
say they got up to 6 numbers. I don't know whether they were all cell phone numbers or landline and cell
have?
phone
The question
numbers,
becomes from
which
who?
they
Chair?
tried.
From who, Chair? Where do they receive them from?
Well, I'm sure they can give you all those numbers
But
if you
the
want.
point, and that's the point I'm going to. Chair.
Yes.
The point I'm going to is that you can. It's not sufficient to say we tried 6 numbers. We need to have tried 6 numbers from credible sources that make it probable that these numbers are yours. So, on these 2 points, one, that this email that they sent it to, they never verified or cross-referenced whether it's still active. They receive it from correspondence and they pick it up online, and they take no further steps to
Well,
verify.
I don't know much about technology.
Yes, sir.
But when you no longer want people to use an email address that is still in your name, are you not supposed to take steps that will make sure people can't use it to communicate with you?
Indeed so, Chair. However, the only source and the only person, the communication thus far, based on what we know, the correspondence only happened with Tlatsana. So if the relationship break down.
No. You said that the relationship between Mr. Van Wyk and the email address
Yes.
is that it's an abandoned email address.
Indeed so, Chair.
So from what you said, it seems to me that it's accepted that it is his email address.
Yes, Chair.
The only difference is that as far as he is concerned, it's abandoned. But it seems from what I hear from the legal team, it seems like it still receives emails. That's why I asked you the question whether if you have an email address and you no longer want people to use it to communicate with you, there isn't something you are supposed to do to make sure nobody can use that email address to communicate with you. Because if there is such a way, then Mr. Van Wyk would only have himself to blame if people continue to use that email address to communicate with him and he doesn't see correspondence that's sent to him because he doesn't check that email address anymore.
I'm with you, Chair, on that line of thinking to a certain point, and then I abandon you, Chair. What you, the proposition that you put, Chair, with regards to how this email would be managed is correct. Where then I then want to abandon you, Chair, is this point, is the source of where this email address comes from is problematic for the Commission. Because if it's coming from a person who's implicating Mr. Van Wyk and it's being gleaned from alleged correspondence, which is now being presented to you, Chair, as fact, to say we have emails where they corresponded, and the veracity of those emails, whether they are authentic or not, hasn't been subjected to the legal process, Chair. And we are now being told this is a legitimate email address based on the correspondence between the parties, on evidence that is not admitted in this Commission yet, Chair, to say is this correct or not. That's the first point. The second point, Chair, is that we then need to look at the time when this correspondence took place. If, like we say, it's an abandoned email address or however many, well, there needs to be a second form of correspondence from someone else who can then say, I too corresponded with Van Wyk on this address. And I'm saying the submissions that we accept as true, everything that comes from Tlatsana, I think is premature. We're not there yet, Chair.
Well, there's an email address that
Yes.
I'm told was used to send the Rule 33 notices to
Yes.
Mr. Van Wyk.
Yes, Chair.
Based on what you have said, that email address is Mr. Van Wyk's email address.
Indeed, so, Chair.
And from what you say or what you have been instructed, he did not receive the Rule 3.3 notices from the Commission.
Yes, Chair.
The legal team of the Commission says they were sent to that email address. And there was nothing that the legal team received back to say it was rejected or the notices were not received into the into that email address. So you say in support of the proposition that Mr. Van Wyk did not receive the email address, you say, but you people used an abandoned address, an email address. And all that amounts to is, it's an email address that belongs to Mr. Van Wyk, but which he has chosen not to check anymore. And the difficulty I have with that is, if anybody chooses to no longer to use an email address that still remains available to people to use, then he can't complain if people use it. That's where I come in. It's common cause, it is his email address. The legal team says the Rule 33 notices were sent to that email address. As I understand it, you are not in a position to dispute that it was sent. But you say, Mr. my client doesn't check that email address anymore because he considers it abandoned. So the question is, as long as it remains available for people to communicate with him, he can't complain if the notices were sent to it.
I can accept it.
You understand that?
I'm with you, Chair.
Yes. So unless there is something else, my inclination would be to allow the evidence to continue. But if you or Mr. Van Wyk wishes to apply for leave to cross-examine, you should feel free to do that. He should feel free to do that. And the application would be looked into in due course. And he will, if granted leave to cross-examine, be able to cross-examine the witnesses in respect of whom he will get leave to cross-examine.
I'm indebted to you, Chair. I think what we wanted to be is to be brought on side with regards to our own non-compliance with
Yes.
bringing all the applications that are necessary, either to bring our own evidence
Yes.
or to cross-examine, etc.
Yes.
So with your condonation, Chair, we asked to bring all those applications and as well as the versions. But where we are short now, Chair, is that what is the process now if we allege that we don't have these notices to then receive these documents
Well,
again?
if you, if for whatever reason it's convenient for you to obtain all of those notices today,
Yes, Chair.
instead of going to check on the email address, I'm sure the legal team will make arrangements to make sure you are given all the notices and everything that was sent to that email address.
That's the only request. We just asked to
Yes.
provide them with a different email address, maybe
Yes.
for them to be resent.
Yes,
And
no, I'm
then
sure
for us to take the
I'm
process
sure that
forward.
can be arranged, yeah.
All
That
right.
can be arranged. Ms. Hofmeyer does here, and she has got colleagues here, so make arrangements with them, they will accommodate you.
I'm indebted to you, Chair.
Okay, thank you. Ms. Hofmeyer, I don't think you want to say anything
No,
anymore.
indeed, Chair. Thank
Yes.
you. We're indebted to you for your ruling, and Ms.
Yes.
Buthelezi will continue.
Yes, okay, thank you.
Thank you, Chair.
Yes.
Our witness for today is Ms. Patudi. She is the current CFO at Northwest.
Your voice is at its lowest.
I'll do my best
Yeah.
to
Your next witness is Ms. Kutlwano Patudi.
Yes, it's Ms. Kutlwano Patudi.
Yes.
She is the current CFO, Northwest Department of Community Safety and Transport.
Yes.
She will be giving us the department version on the SA Express and the Northwest Department of Transport relating to the agreement in question. May I ask that the witness be sworn in?
Okay, please administer the oath or affirmation.
Please state your full names for the record.
My name is Kutlwano Ingrid Patudi.
Do you have any objections to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you solemnly swear that all the evidence that you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair.
Thank you. Before you proceed, I had in mind that we would take lunch at the normal time, which is 1 o'clock, but we have had some delay. It would be better that we finish with Ms. Patudi, I think, before we take the lunch break, so that when we come back, we can go into the next witness. So I see her statement is 10 pages.
Yes.
I imagine that we should be able to finish, what, in 30 minutes? 45 minutes?
Yeah, 45
At
minutes
least
to
not
an
later,
hour.
not more than an hour.
Not more than an hour, I'll try.
Or at least, let's see whether we can't finish by maybe 1:30.
One. Yes.
If we haven't finished by then, we'll take the lunch break anyway. Is that fine?
It's noted, Chair.
Okay.
Chair, the affidavit of
Ms. Patudi, I've just changed the lunch arrangement. Is it fine with you, or were you having some plans for lunch?
No, it's okay, Chair.
It's okay, all right, thank you. Let's go ahead.
Chair, the affidavit of Ms. Paturi is on exhibit DD7. So, Chair, there is an
The liver arch file containing Ms. Patudi's statement will be marked exhibit DD7.
Chair,
Yes.
there is a statement of the current HOD for the Department of Transport Northwest. That's the statement of Ms. Mofokeng that has been added to this bundle. We don't intend to call oral evidence for this witness. She is merely corroborating the evidence of Ms. Patudi.
Okay, no, that's fine. At some stage, we will need to, read out important features of the affidavit so that if we are not going to lead her evidence or his evidence,
Will
so
do so.
that the public has an idea that what she or he was going to say.
We'll do so, Chair.
Okay.
Ms. Patudi, would you please turn into exhibit DD7, page 1?
Okay.
Do you confirm that is the affidavit you made for the commission?
I confirm that this is the affidavit I submitted to the Commission, Chair.
And you confirm that the signature on page 10 of this document is your signature?
I confirm that the signature on page 10 of the affidavit is mine, Chairperson.
Yes. Are there any corrections that you would like to make on this affidavit?
Yes, Chair. On my affidavit, on point number 17.
Paragraph 17?
Oh,
on-
paragraph, yeah.
On page
paragraph-
4?
Paragraph 17 on page 4. The sentence reads, as per SLA, the department was to make a prepayment subsidy to the value of 112 million relating to 2014-15 financial year. It should be 2015-16 financial year.
So we changed 2014 to reflect 2015?
Yes,
And
and then,
2015 to be 2016?
yes.
Thank you.
And then paragraph 18, the department received an invoice from SA Express valued at 51 million. This should be, the 51 million should read 50 million, and the correct invoice was provided, or has been provided.
Yes, there is an invoice attached as annexure KP3 on page 65 of your affidavit. Chair, may I request that that invoice be exchanged for this correct invoice? Annexure KP3?
Yes, okay, thank
Yes.
you.
I have numbered this invoice as per what is on annexure KP3. She has it.
Okay, the other correction is on paragraph 38. 38. The amount stated on the first line, Velotech issued their first invoice of 15.06. It's actually 15,850. So this was an error, but the attached invoice is of the correct amount.
Is it 15,850,000?
Yes, Chair.
Okay.
The last correction is on paragraph 39. The first sentence there says, Valotech was appointed to do ground handling services sometime in 2016. we want to add the month there is sometime in June 2016.
What paragraph did you say that is?
It's paragraph 39, Chair, the first sentence.
Yes, just tell me what you're saying about that.
It's the first sentence reads, Valotech was appointed to do ground handling services sometime in 2016.
Yeah.
The correction that we are making is that Valotech was appointed to do ground handling services sometime in June 2016. We missed the month there. So we are putting that in.
Thank you.
These are all the corrections that we'd like to make.
Thank you, Ms. Paturi.
And you will prepare supplementary affidavit
We'll do
to
so.
take care of that.
We'll do so, Chair.
Okay.
Ms. Paturi, would you please give us your credentials, your qualifications, and the position that you currently hold?
Okay, thank you, Chair. My qualifications, I have a BCom degree, and my major subjects were accounting and management. Further to that, I also did a master's in business administration, the finance stream. My current occupation is I am the CFO for the Department of Community Safety and Transport Management in the Department of Northwest. I held this position since July 2013 to date. Before I was appointed as CFO, I held the position of Director Finance in the same department from 2009 to July 2013. Thank you, Chair.
Thank you. And who do you currently report to?
I currently report to Ms. B.A. Mufokeng, and I started to report to her from the 1st of April 2017 to date.
Yes.
Before her, I reported to Mr. Buti Chuma, who was acting HOD from 22nd of August 2016 to 31 March 2017. Before Mr. Chuma, it was Mr. Wahem Musiani, who was also acting as head of the department from the 1st of April 2016 to the 21st of August 2016. Ms. Cecily Mpulukeng acted for a few days from the 15th of March 2016 to the 31st of March 2016. And then before that, before the acting positions, it was Mr. Bailey Mahlakuleng, who was the head of department from 2013 to March 2016.
So at the time of conclusion of the agreement between SA Express and your department, Mr. Mahlakuleng was the HOD, is that
Yes.
correct?
Yes, Chair. Mr. Mahlakuleng was the HOD at the time.
Yes, and on paragraph 6, you deal with what your position as CFO entails. Could
Okay.
you briefly place that on record?
Okay. Chair, as the CFO, I oversee the general financial management of the department, and this includes, but not limited to, supply chain management, budgets, and expenditure management.
Yes. The purpose of your evidence before the commission is to enlighten us as to how the department ended up having this contract with South African Express. In paragraph 7, you talk about the intention of the department to revive the Mahikeng and Belanisberg airports. How far were the plans of the department in as far as that as reviving these airports were concerned at the time?
In the year 2014, Chair, the department had included reviving the airports as an activity or priority in their 2014-15 annual performance plan. But that was at a very early planning stage, to the extent that at the time there was no budget allocation yet. So on the 26th of August 2014, the Northwest government, led by the Department of Tourism, was invited to Sun City. I was invited. The invitation was for was to hear a presentation from 6 airlines that were invited.
And sorry, who invited you? Who was responsible for that meeting?
I was invited by the office of the HOD at the time.
And who called or arranged for this meeting that took place on the 26th of August 2014?
What the office of the HOD confirmed was that the Department of Tourism was the one that had coordinated the meeting and had sent the invite to the department.
Yes. And proceed, you said 6 airlines were invited to make presentation?
Okay, 6, according to the information received at the meeting, 6 airlines were invited to come and make presentations, but only 4 of those airlines showed up and they made presentations.
Ms. Patudi, if I may ask, was your department involved anyhow in selection of the 6 airlines that were
No,
invited?
our department was not involved in selecting the airlines. I specifically was not involved in the selection of the airlines.
Do you have any knowledge on how they were selected?
I don't know how they were selected.
Yes.
Yes.
Then only 4 came, then what happened?
Yes, only 4 came and they made a presentation to the collective that was there. The departments that were in that presentation was the Department of Community Safety and Transport Management, the Office of the Premier, the Department of Finance, and the Department of Tourism. Those are the departments that were present in that presentation.
And then following that presentation, take us to the events that followed that presentation. In paragraph 10, you speak about a memo that was addressed to ESCO after this presentation.
Yes, after the presentation, I'm aware that the HOD prepared or the department prepared a memo summarizing the proposals made by those service providers or the potential service providers, the airliners that were there.
Yes. When you say the department, were you part of formulating this memo?
I was not part of formulating the memo.
Were you conducted?
Sorry, ma'am?
Were you conducted for you?
I became aware of the memo after it was finalized.
Yes, proceed.
Yes. The purpose of the memo was to make a presentation to the EXCO, which is the Executive Council of the province, to present to summarize what happened in the presentations that were held at Sun City.
Yes. And what were they asking for? What were the recommendations?
Sorry, Ms. Buthelezi. The background leading to the conclusion of agreements that were concluded by the department and SA Express, we don't need to get too much into it. And much of it, I assume, will not be in dispute in terms of what the provincial department did. So you can just lead her quickly in terms of that. Otherwise, we need to get to how the agreement was concluded, whether she accepts that that is an agreement that was concluded between SA Express and them, and then deal with how the circumstances, if she knows them, of how it came to be concluded, and then we move on.
Thank you, Chair. Ms. Mofokeng, do you confirm that on that, Patudi, do you confirm that on that memo there was a recommendation that the 2 airports be revived and that SA Express be appointed as a supplier, and that is on page 20 of the recommendation that was sent to EXCO?
And if you know that that's what's in the memo, you don't have to go to it.
Yes, Chair, I confirm that
Yeah.
that is what was on the memo.
Okay.
Thank you. And do you also confirm that the said memo was signed by the HOD at the time, Mr. Bailey Mahlakoleng, and the MEC, Mr. Hauake Oakeng Molapisi.
I confirm that, Chair.
Yes. What I want to understand from you, Ms. Mofokeng, is it,
Patuti.
sorry, Ms. Patuti, is
What's
it?
wrong with the evidence leaders this week?
I'm having a Gwenya moment. I apologize, Chair. Ms. Patuti, do you, what I want to understand from you is that, is it procedural for your department to seek approval from ESCO before the appointment of service providers?
The process for appointment of service providers, Chair, would be that the department would advertise a bid if it was one of the priorities that were budgeted for, that would be
Sorry, Mr.
included.
President, I've been requested to ask you to bring the mic closer to you.
Oh,
Thank you.
thank you. Sorry, Chair. The process, the correct process would be that the department would identify priorities or projects that they would advertise or, they would advertise or go out on tender for in a particular financial year. Those will be included in their plans, in the procurement plans, and that would be budgeted for. So what would happen is that the department would go out on tender, advertise, and go through the normal departmental bid processes where the specifications would be presented to the bid specification committee and for approval by the head of department, but will also go through the bid adjudication committee for recommendation. And once the advert has been advertised and closed, the bids would be evaluated and adjudicated, and the HOD would approve. So that is that's a summary of how the process of appointment should be. The appointment is done and concluded by the head of department.
Yes. And in this particular instance, you confirm that no supply chain management processes were followed?
Yes, this project was not advertised, did not go out on tender.
Yes. As a CFO, what was your view on this, in this instance?
My view was that this needs to be advertised. The department needed to go out on tender. I advised the HOD to say, especially because it was a new environment to us. It was the first project of its kind. We did not know what was on the market, what the market could offer, generally including pricing and costing and all that. So it was advisable for the department to go out on tender so that we could get the best, the best option that could be offered by the market. So my advice was that we go out on tender, but that advice was not taken. The response was that the collective at the meeting of Sun City has recommended that the process be taken up or a memo be prepared to EXCO and this be presented to EXCO for approval.
And who formed part of that collective that made that decision?
At the Sun City meeting, as indicated earlier, it was the Department of Tourism, Department of Community Safety and Transport, Treasury, and the Office of the Premier. I don't remember, Chair, who represented the Office of the Premier, but for the other departments, the HODs and the MECs for all the departments were there. And I also, together with the Chief Director responsible for transport operations, were invited.
Yes, so the decision to appoint SA Express was made by those four, the MECs and HODs from those four departments?
I would, Chair.
I think she said recommendation.
Yes, the recommendation to go to EXCO with
A proposal.
the proposal to appoint SA Express.
Thank you.
Do you know the names of the You said you didn't know, I think, who represented the Office of the Premier.
I don't
think.
remember who.
Yeah,
it
but
is.
tell us the names of those who represented the other departments at that time, if you know them.
I don't, the Department of Tourism was represented by the acting HOD at the time. It was Mr. Charles Ndabeni who represented the Tourism Department.
Mr. Charles Ndabeni.
Yes, Chair.
Okay.
The Department of Community Safety.
What was his position in the tourism department, if you remember?
He was acting HOD at
acting
the time.
HOD.
Yes, Chair.
And then the other department?
Department of Community Safety and Transport was represented by Mr. Bailey Mahlakuleng.
Mr.?
Bailey Mahlakuleng.
Okay. Do you want to spell the surname for the sake of the transcribers?
Okay, Mr. Mahlakuleng is MAHAHLAKOLENG.
Yes. And what was his position?
The head of department for
He was
community
head of
safety.
department of your
Yes,
department?
Yes, Chair.
Yes.
And the treasury, the Department of Finance was represented by Mr. Israel Kunene. He is the head of department.
Okay, no, thank you. But you were part of that meeting?
I was in that meeting, Chair, but I must also state that I tried to get the minutes of the meeting. I couldn't get the minutes because I don't remember whether there was a meeting after the potential or the airliners presented where formally the decision was reached. So I wanted to refer to the minutes.
So is the position that although you attended the presentations that were given by airlines, while you were there, no decision to recommend anything was taken by a group of people that included the two HODs you are talking about and the acting HOD and yourselves. You are not party to any such decision, whether it's a recommendation.
Yes, Chair, I was
You are
not
not
party to to that decision.
You left after the presentation,
Yes, Chair.
and when you left, were the other people who came, who represented different departments still there? Did they remain?
I don't know whether there was another meeting after
Yes.
this one, but
Yes.
what I know is that after the presentation, we left and I was not part of the decision.
So the other person, you say we left, the other person that you left with, I assume, was the acting HOD for your department? Or was
No.
the HOD?
I didn't come with him. After the
You left on
presentation,
your
I
own?
left on my own. Yes, Chair.
And when you left, the rest of the people were still there who came from different departments? Or you don't know?
Chair, I don't know.
You just left after the presentations?
Yes, Chair.
Okay.
Yes.
But subsequently, you say you were told that they took a decision.
Yes, subsequent to that, when I spoke to the HOD at the back home at the department,
Yeah,
to say
the HOD of your department.
the HOD of my department,
Yes.
that my advice is that we go out on tender because this is a new project and it's a big project. We've never had this type of project before. We don't know what the market offers, what's available in the market. We go out on tender to advertise. And then his response was that the collective, there's a recommendation that SA Express be appointed, and a memo to that effect was prepared for presentation at Exco.
How soon after that presentation did you have this conversation with your head of department?
It was
a week, a day, 2 days, a month?
It was within a short space of about maybe 3 days or a week.
Oh, okay.
Yeah, around, it was a short space of time.
And he said to you that a decision to make a recommendation to Exco had been made by a collective, by a certain collective.
Yes,
And the collective he was talking about,
he's,
which one did you understood? Who did you understand him to be talking about?
he said the collective that was at the meeting of,
The presentation.
yes. So I'm not sure who exactly,
Yes.
whether it was the HODs or both HODs and MECs.
Yes.
That is why, Chair, I said I tried to locate the minutes of that meeting so that I could have,
You could
The-
have something in writing.
yes, Chair.
Yeah. Did you ask him for a copy of the minutes?
He's no longer in the department, so he,
No, but I mean at that time, when you, after this conversation and you were looking for minutes,
no,
or you only looked for minutes for purpose of this commission?
yes, I tried to locate them for the purpose of the
Oh.
commission, yes, Chair.
Okay, so your conversation with him then ended on the basis that he was saying that a recommendation had been made that ESCO should appoint or should decide to appoint that SA Express should be appointed.
Yes, Chair.
And did you ever have another discussion about this issue with him in regard to in regard to the way forward, or that was the end for that time?
I don't remember having another meeting or
Conversation
conversation
with him.
about this, yes.
Okay, all right. Thank you. Proceed, Ms. Buthelezi.
Thank you, Ms. Patuti. Was it at the stage when this memorandum was being prepared for the ESCO when you had this discussion with HOD?
Yes, Chair, because it's at the time when he told me that the department will be presenting that EXCO memo.
Okay. For the benefit of everyone, when you refer to ESCO, who is ESCO?
EXCO is the Provincial Executive Council, which comprises of the Premier and the MECs.
Yes, and then what is a role of ESCO in the appointment of service providers?
Like I indicated, Chair, before, I indicated that the service providers there's a process of appointing service providers internal in the department.
Yes, and does that ever include EXCO
No.
in your experience?
No, Chair.
Before this happened, it had never included the EXCO, as far as you know.
As
had
far as
never
I
been
know, Chair.
included in the appointment of service providers.
Yes, Chair. It doesn't.
Yes,
Yeah.
okay.
So this was an exception?
Yes, it was
And
different.
did ESCO in fact take that decision that SAX should be appointed? Was that decision made?
Yes, Chair, I later got a copy of an extract from the EXCOM resolutions, which said EXCO agreed with the recommendation of the department.
Yes, we now know that.
I'm sorry, Ms. Buthelezi, just remind me, on what page is that memo that you talk about?
The memo, it's Annexure KP1. It's start from page 12 up to page 21.
Under
One,
which divider?
number 1.
Is this is this the memo that went to EXCO and recommended that SA Express be appointed?
Yes, Chair, this is the memo.
And it was signed by the head of the Department of Community Safety and Transport, and and the MEC for that department, Mr. Is it Kharafe Mulapisi?
It's Hawaii Waheng Mulapisi.
Oh, Hawaii. Okay, thank you. I'm sorry about that. So, and did EXCO approve the recommendation? Did they accept the recommendation?
Yes, Chair, there was an extract from the EXCO.
Chair, if I may be of assistance.
Yes.
If I could refer you, there are papers that we added to your bundle on page 381. It's right at the end, towards the end of the bundle. There is an extract of ESCO minutes dated 3 December 2014.
So you say, yes, EXCO did approve the recommendation? Or have you reached page 381?
Yes, Chair.
Yes.
The extract that I was referring to has, at the bottom there, there's a heading that says resolved that.
Yes.
It says EXCO agreed that the department should proceed with the chosen service provider and sign the contract. And in brackets it says SA Express. And also that the submission should serve again on December 2014 with a proper analysis of presentation and options for considerations by EXCO, for consideration by EXCO.
This is strange. EXCO, according to this extract, you say it's an extract from the minutes of the Northwest EXCO meeting of 3 December 2014. Under resolved that A says EXCO agreed that the department should proceed with the chosen service provider and sign the contract, and then says SA Express.
Yes, Chair.
And then B says the submission should serve again on 15 December 2014 with a proper analysis of presentations and options for consideration by EXCO. Do you see what I see as strange there, or is that, or do you see that there is something strange with that?
Chair?
You don't see anything strange there. Do you see anything strange in those two sentences of what they resolved?
They resolved on the appointment, so.
Well, the resolution on the appointment is one thing, but I understand B to be that although they had already resolved that the department should proceed with the chosen service provider and sign a contract, they were still going to receive an analysis of the presentation afterwards.
Yes, Chair.
Is that your understanding as well?
Yes, that's how I understand it, Chair.
That seems strange to me. I would have thought that they would have wanted, assuming that they are the ones who must make the decision, and assuming that the processes have been followed, or that there is justification for not following processes, I would have expected that they would first say, before we can make a decision whether the department should go ahead and sign an agreement with SA Express, we want to see an analysis of the presentations, and then we'll make our decision after that. But these minutes say the department must go ahead and sign a contract with SA Express, and then an analysis of the presentations must come later. I find that strange. Do you also find it strange, or is there something I'm missing?
Yes, Chair, I hear what you're saying, Chair. It would have been better, or it would have made more sense if they received the presentation before deciding.
Well, maybe you are putting it lighter. I mean, how do you start by making a decision?
Yes.
And then afterwards, say, bring me the information that I need to make a decision that I've already made. This is stranger. This is more stranger to me because I've had the past few days and maybe last week, a few of instances where decisions are made without the necessary information, at least on the information that has been, on the evidence that has been given by certain witnesses, and I don't know, other witnesses might come and say it's not true, we did have all of that information, but on the evidence given by certain witnesses, certain bodies just made decisions to have contracts concluded with certain service providers without enough information, and then they say the information will come later. So that's, I just see what may appear to be a pattern here. Yeah, okay, please continue.
Thank you, Chair. Ms. Patudi, in your affidavit on paragraph 14, you do make a comment that the appointment of SA Express was not in line with the provisions of section 217 of the Constitution. When did you make this realization?
Chair, this refers to the fact that this bid or this project was not advertised. So I know for a fact that it was not advertised because immediately after, or what followed after the meetings at Sun City was an EXCO memo which I've already spoken to.
And you would have known if the procurement processes were followed?
I would have known, Chair, because as the CFO, I'm also chairperson of the bid adjudication committee, so I would have known because the specifications would have been presented to the bid adjudication committee, and all those SACM processes would have.
Yes, and you had advised that processes should be followed, but your advice was not accepted by the HOD of your department.
Yes, I did, Chair.
Yes. Are there any circumstances which existed which justified not following procurement processes as far as you are concerned?
I don't know of any, Chair.
You don't know of any. As far as you are concerned, there was no justification for not following processes?
There might have been, Chair, but I'm not aware of
Yeah,
them.
I'm saying according to, as far as you know.
As far as I know, Chair.
Yes, yes. And what do you understand the normal exceptions to be where those processes would not be followed? Your own understanding?
Chair, prescripts do allow for deviations, but it would be in exceptional or specific cases. For example, in emergency appointments or in urgent or where there's sole service providers, but then an approval would have been sought before concluding.
Yes, well, I guess that even with a deviation, if you ask for it, you apply for it, and it's granted.
Yes.
It is a process itself.
It's a process in itself.
You can't just not do anything and say there is justification. You've got to follow a deviation process.
Yes.
So, are there any circumstances, as far as you know, where a department can simply not follow any process, either a deviation process or the normal procurement processes?
No, Chair.
You don't know of any such?
Yes, Chair.
Yes. And you have been CFO in the department since 2013?
Yes, Chair.
2013.
Yes, Chair.
During your time, you have never had such a situation, have you? Where you have come across a situation where it is said that there is justification not even to apply for deviation?
No, Chair, I've never come across that, yes.
If you don't follow normal procurement processes, you are obliged to
deviations.
apply for deviation.
Yes, Chair.
You can't not follow those processes and not apply for deviation.
Yes, Chair.
Okay.
Thank you, Ms. Patudi. We are aware that eventually SA Express was appointed, and there is an agreement that is under tab 2, Chair, that was signed with SA Express on the 31st of March 2015. Who participated in drafting this agreement on behalf of the department?
Chair, the department has a legal division, the directorate responsible for legal services. They are the ones who drafted the service level agreement between the department and the SA Express.
On whose instruction? Is it the HOD?
Yes, it would be the HOD.
Yes, I could see on page 57 that this agreement is signed. Do you recognize the signature that is on page 57?
Yes, Chair, the signature on page 57 is that of the then HOD, Mr. Bailey Mahlakuleng.
Yes, and we were told by Mr. Piri yesterday that for SA Express, the person who signed, in fact, his name is spelled out there, is Mr. Inatinjanga. You do confirm?
Yes, ma'am.
On page 57, I see one signature, or is it two?
Yes. The next signature,
The
Chair.
one is under signature, and then below that it says signed at, or the signed at is Mahikeng, and it's 2015, I think, or is it 2013?
It's 2015, Chair.
2015.
Yes.
Looks like 2075. And above that signature, what is written is signed for and on behalf of the Department of Community Safety and Transport Management, Northwest Province. You say that signature, you do recognize it as the signature of the then head of your department.
Yes, Chair.
Okay. Thank you. Ms. Butches, you wanted to say something?
Thank you. I wanted to say on page 58, there is a signature for a person who signed on behalf of SA Express. And that signature was identified as that of Mr. Inatinjanga by Mr. Piri, who had testified earlier on. You do confirm?
Yes. No, that's fine.
Thank you.
Now, Ms. Patuti, this agreement, it starts at page 23, is that? Yeah, it starts at page
Yes.
23. When did you become aware of the agreement for the first time after it had been signed?
Chair, I became aware of the agreement after it had been signed when there was a claim.
And that would have been with 2015?
Yes, 2015.
2015.
Yes.
Okay, all right. You were earlier on saying that your legal department would have prepared the agreement after getting instructions from the HOD. Ms. Butchers, you can take it from there.
Thank you. And who represented SA Express when the negotiations were done?
The SA Express was represented by Mr. Brian van Wyk.
Thank you. And
Were you present at some of the meetings where the agreement was negotiated?
No, I was not part of negotiating for the agreement.
Yes.
Yes, Chair.
But how do you know that Mr. van Wyk represented SA Express?
Chair, she said at meetings.
when the
Do you have any personal knowledge as to who represented the department first at negotiation meetings before the conclusion of this agreement? Do you have any knowledge of who represented your department in negotiations that resulted in this agreement?
It was the HOD, the head of
HOD.
department, yes.
Yeah, and
Yes.
how do you know that?
Because he signed the agreement eventually.
Yeah.
And legal services also confirmed that he's the one who gave instruction for them to draft the service
Yes,
level
but
agreement.
you never attended any meetings if there were meetings.
For the drafting of the,
Yeah.
no, there were no,
Yes.
I was not part of.
But you say you are aware that this agreement was drafted by
Our legal.
your legal department?
Yes, Chair.
Okay, and then it was presented to SA Express, or you don't know?
I
You just knew when it was signed?
I don't know, Chair. I don't
Oh,
know.
but it was
the
drafted by
process.
the legal department?
Yes, yes,
Okay,
Chair.
all right.
Yes. You say you became aware of this agreement when a claim was submitted. Who had submitted this claim?
maybe I must talk, Chair, to the process of
Yes, that's
processing
fine.
the claim.
Do so.
Yes, the end user, which is the program or the program manager for a particular project or program, would receive an invoice and then prepare a requisition for payment and approve. The chief director would approve, or the director. In this instance, it was approved by the chief director and then sent to the head of department for the final approval. So when the claim has been approved, the SLA would be attached, and also there would be checklists and just for each and every stage of the process to confirm compliance to certain things or areas. So that process happened, and the payment came to finance for verification for compliance check. And then I noticed that it was actually 2 invoices that were presented, the one for SA Express and the other one was for the management company.
What was the management company's name?
It was Coroneka.
Yeah, so there were 2 invoices.
Yes.
And what were the amounts? If you are able to say, even if it's not the exact amount.
Coroneka was around 20 million.
Yes.
And the SA Express was around 51.
Okay.
Yeah.
And these 2 invoices came at the same time, more or less at the same time.
Yeah, more or less at the same time.
Okay, all right.
And then I refused to process the management company invoice,
Yes.
Chair, raising an issue that on clause 6.1 of the agreement, which is on
To
page
go there, clause 6.1.
6.1, which is on page 31.
Yes.
The clause says the department shall pay to SA Express annually in advance the amount stipulated in Annexure A, which amount is subject to review at the end of each year by agreement between the parties. So this does not talk about a management company. It talks about SA Express.
Yes.
That is why I said I cannot
You said I can't pay. What is the basis for
paying the
us
management
paying Coronong?
Coroneka.
Coroneng.
Yes,
Okay.
yes, Chair.
I'm sorry.
And also, it was not only this clause, Chair.
Yes.
There's another clause, 15.1,
It's on page
It's
44.
Coroneng, Coroneng,
Coroneka.
Coroneng,
It's Coroneka.
Coroneka.
K-O-R-O.
Yeah, no, I saw it
N-E-K-A.
earlier, but I seem to get it wrong all the
Coroneka.
time. We have been dealing with it the past 2-3 days.
Yes.
Okay, all right.
Yes.
Maybe it's this break from yesterday, 11 o'clock to now.
Yes. And
Yes.
the other clause you referred to is that clause 15.1 on page 44.
Yes, Chair, which says SA Express shall, in consultation with the department, appoint a management company responsible for managing certain facilities at Johannesburg and Mafikeng Airport. So I raised an issue. I said I need to know how this was complied with, meaning how was the management company appointed, who represented the department, how was this consultation, how did it happen? And obviously that did not happen because there was no proof
Yeah.
that the department was involved in the
Appointment.
appointment of a management company. So on that basis, I said I am not going to pay
The
a
management company.
Yes.
Yes. And then what happened
Okay,
from there?
I'm sorry. I think it's time we should take the lunch break.
Thank you, Chair.
We are going to take the lunch break. It's about 29 minutes to 2 now. We will resume at 2:30. We adjourn.